What we haven't talked as much about is the impact of the lack of water that we are entitled to today during the summertime. The work through the design and Director Bradley's team that they did on the hydrology started to give us more sense and scope and be able to quantify a little bit better really the degree of the breach from Colorado. And just to give you some sense of what we think from a conservative basis, we think that we have lost out on over 1 million acre-feet of water during the summertime. So put aside the Perkins County Canal itself during the summertime, not just in the last year, over a period of time. That's a significant amount of water that has an enormous amount of value. Just that water alone is valued conservatively in the 9 or 10 figures, potentially over $1 billion, depending on how you measure it. So that's the second work stream. That also sort of has culminated very recently. And the third is the conversations that I've had and my team has had with our counterparts in the Colorado Attorney General's office. We've had a number of productive conversations over the last year and a half to try to narrow the issues of dispute between Nebraska and Colorado, to try to understand their legal position, to see if there's a way going forward where we could reach an agreement. And it became clear, despite the very professional and intentional scope of those negotiations, that we were at an impasse. And let me just give you 2 examples of things that we disagree on, that we could not move forward on actually building the canal without resolution. And these are issues that only the United States Supreme Court can address and resolve. The first one is the scope of the eminent domain right. We don't think there's any other compact in the history of the United States, and there might be one, so I don't want to say this definitively, but we are not aware of any other compact that gives one state, in this case Nebraska, the right of eminent domain in another state, in this case Colorado. The 1923 compact gave Nebraska that right. There's a threshold question. Where do we exercise that right if we have to exercise eminent domain? Do we do it in federal court in Colorado? Do we do it in water court in Colorado? Do we do it in state court? There's a disagreement between Nebraska and Colorado as to even where to start enforcing our rights under the compact. Another example is the size of the canal. We think that the canal gives us entitlement to at least over 500 cubic feet per second. They think that's not a floor, but that's a ceiling. That impacts the size of the canal. We can't build the canal without that having been resolved. There are other issues that we've identified from those discussions with Colorado. It's helped crystallize the issues that will be before the United States Supreme Court, but it made very clear that the next step to defend Nebraska's rights under the 1923 Compact is by filing this lawsuit with the highest court in the land, who has the authority, the only court that has the authority and the ability to resolve these particular issues between 2 sovereign states.